After divorce, some parents find themselves chained to the very ground they once called home, not by love, but by legal uncertainty. The truth, you can relocate with your children, but you'll need more than hope and heart. You'll need strategy, evidence, and an unwavering focus on one thing: the best interests of the child. Let's begin. The legal foundation, South Africa's Children's Act, Section 7, makes it clear. Every decision affecting a child must prioritize their emotional, social, and educational well-being. It doesn't matter how your ex feels about the move. What matters is why you're moving and whether the child will thrive. So what does the court look at? Let me break it down. The child's needs. Will they have educational continuity, emotional support, a stable environment? Think, will a grandparent or a step-parent be present? Will routines stay intact? The reason for the move. Is it bona fide? A career opportunity? A family reunion? Or is it a disguised attempt to cut the other parent out? In Godbeer versus Godbeer, the court backed the primary caregiver's decision because it was mature, rational, and focused on the child's welfare. The non-relocating parent. The court wants proof you've planned for their continued involvement. Offer digital calls, structural visits, even flights. Show good faith. In Jackson versus Jackson, the SCA refused to block a relocation because the plan was reasonable, the intention was honest, and the child's needs came first. And the child's voice, it matters. Section 10 says children of sufficient age and maturity must be heard. This is where the voice of the child assessment comes in, conducted by a social worker or child psychologist. In the case HG versus CG, the court listened to an 11-year-old and 14-year-old. Their opinions shaped the outcome. Parenting plans, your legal shield. If you've divorced or never married, you need a parenting plan. It covers primary residence, visitation rights, financial support, guardianship rights. Relocation doesn't erase a parent's legal guardianship, but it does require consent or a court order. What if your ex won't agree? Start with mediation. Try to negotiate. If that fails, you apply to the High Court. This is not a casual application. You'll need reasons for the move, alternative contact arrangements, expert recommendations, and yes, your child's voice, if they're mature enough to express it. The risks: relocating without consent can backfire. You could face allegations of parental alienation or urgent interdicts. It's not just bad for your case, it's bad for your child. But here's the nuance. If your ex has barely exercised contact, or if there are concerns about their safety or consistency, that too will come out, and the court will weigh it. Case in point, JB versus RE 2023. The court supported the relocating parent because the plan was sound, the child's relationship with the other parent was protected, and everything was done transparently and legally. So what should you do practically? Negotiate a parenting plan. Set expectations early. Use a mediator or attorney. Avoid emotional explosions. Do a voice of the child assessment if your child is old enough. Go to court if you must, but go prepared. Final word. Relocation isn't about escape. It's about elevation. And when done right, with clarity, with care, and legal integrity, it can be the beginning of something better. Not just for you, but for your child's future. At my firm, ST Law, we specialize in these matters. We'll help you plan the path, protect your rights, and keep the co-parenting relationship steady, even across borders. Because in the end, the law may chart the route, but love decides the destination.